Then for time limit, we have 29A arbitration for passing the award. Now I think it is after the completion of pleadings, 12 months. By consensus, another 6 months. The court can further extend by 6 months. And you will have consequences when you go to court. Like arbitrator may loses part of his fees and things like that. Then you have an fast track arbitration. I think that this was also mentioned by IMBA last time. That is 29B. We go for a fast track arrangement that also requires the consensus of between the parties, and you can adopt this document only measures and other things to complete the arbitration within a period of 6 months. Then you have Schedule 5. This was the biggest problem that was discussed in the our Schedule 4 in our Law Commission report, that the fees being claimed per sitting and empty sittings and so on. In order to deal with this, we have a schedule incorporated for determination of the fees of the arbitral tribunal, and we also have, there is also a provision there that you can, the respective high courts can formulate fees taking into account the schedule 4. And I believe that Kerala High Court has also made a schedule which is lesser than what is provided in the schedule 4. Then we have 23 and 24. For adopting sensible case management techniques. We will be talking about case management probably next Saturday. So I don't want you to take you to the case management. But I think that an amendment to the Code of Civil Procedure in the light of the Commercial Courts Act, and they have a case management method incorporated. And briefly stating, you will have a script ready when the arbitration process starts. Both parties know what is the dispute, what is the nature of evidence that should be brought in, whether expert is necessary or not, whether oral evidence is necessary or not. And all these things are known to the parties who are arbitration professionals. So before the first preliminary meeting, both the parties will have their modus operandi for approaching this arbitration ready. It's not like the litigation, this thing, at the last day when the list is there, we will file an app saying that I came across a document yesterday, so I am producing it today. This list, we have to be, it has to be removed from the list. Those people who are practicing in the civil courts will know what kind of applications will come at the last day. Here it doesn't happen. Especially we are talking about international arbitrations where we have a complete script ready and we take call sheets from arbitrators. And the arbitrator at the oral hearing, at the date of oral hearing, he will come prepared after reading the entire pleadings and all the witness statements and everything. And in the next 5 days, it is a residential program, and maybe in the 3rd day, you can get an award. It is how it works. So the case management in arbitration seems to be one of the important topics which we will be discussing. And procedural order number 1 will be, see, we have a time limit of 1 year. How do you complete this arbitration within 1 year? This will be designed in the first meeting itself. And if somebody comes and requests for time, cost will follow. And cost is a very important factor in arbitrations. So people would stick to their... And regarding the second principle, that is party autonomy, we will find that Section 10 the parties will have the right to decide upon the number of arbitrators 1, 3, 5, 7, 9, 11, any number, but it can only be odd numbers. Procedure for appointing the arbitrator can be decided. Qualifications can be decided. Then procedure for challenge. Please read the section. You will find this term included there. Unless otherwise parties or unless otherwise agreed by the parties, or they will speak about every clause which we are referring here will start with such a provision regarding an agreement between the parties. If there is an agreement, these clauses will not apply. You can have agreements regarding these things at the time when the contract is made. So sensible making of contract is very, very important, rather than leaving it to a judge of the High Court or the Supreme Court to appoint the arbitrators. You can specify all those details. So party autonomy is available under section 10, 11, 13, 19. Procedure to be followed by the tribunal in conducting the proceedings. You can very well say that I don't want oral hearing. I don't want reasons also for my award. I just want to know whether I win or he win. You can still say that I don't want any reasons. If there is an agreement to that effect, well and good. Your arbitration award will not have any reasons. Section 22 says that the language, I think that language or languages to be used in the arbitral proceedings. 23 speaks about the period within which the statement of claim and defense to be filed. There also you can have agreements. 24, whether to hold oral hearings for presentation of evidence or oral arguments, or whether the proceedings shall be conducted on the basis of documents. 26, parties can agree upon regarding the appointment of expert. What kind of an expert, whether the parties will appoint or the tribunal will appoint, qualification of the and so on. And 29, again, the fast track procedure. In the English Arbitration Act, you need not search and find out which clause is mandatory and which clause is non-mandatory, because the Schedule 1 of English Arbitration Act contains all the non-mandatory provisions in Part 1. So if a particular clause is not included in the schedule, then it is non-mandatory. You may also refer to section 4 of the arbitration. Section 4 of the English Arbitration Act, which deals with mandatory and non-mandatory provisions, and also the schedule. How do I come out of this? So we come to the third principle contained in section 1 of the English Arbitration Act, that is limited court interference. And I don't want to take you too seriously into these provisions because we will be discussing it. Section 9, interim measures, injunction, attachment, appointment of receiver, protection of subject matter, etc. We can move the court. Here it is the commercial court as of now. Section 2.2, this is a very important inclusion in the Arbitration Act. Normally, the rule is that Section 9 would apply in where the seat of arbitration is in India. But even in a foreign, even in an international arbitration where the seat of arbitration is in India, if the assets are in India, still you can approach the Indian courts for reliefs under Section 9. This is, I do not know in real terms how it actually works, in the sense that you have an international arbitration agreement. One of the parties is a foreigner. The other party is an Indian party. He has assets. He is a defendant. The seat of arbitration is Singapore. Still, the party can approach, the foreign party can approach the Indian court for freezing his assets before the arbitration proceeding starts. This is one of the important innovations of, I think that this is a good provision that we have in Arbitration Conciliation Act. Then we have 13, termination. We have instances where the arbitrator does not discharge his functions, or he is unable to discharge his function. Then we will have to employ the termination of mandate. I'm not very sure whether this section is number is correct. It should be 14. And when you can approach the court saying that the mandate of the arbitrator is terminated because he is not discharging his functions. So there is a possibility of substitution of an arbitrator, but the same procedure for appointment of the arbitrator will have to be followed for the purpose of making the substitution. And that arbitrator can continue with the arbitration from the stage when the court says that the mandate is over. For this purpose, we require the court, because all arbitrators, especially in India, we have ad hoc arbitrations happening. So nothing is permanent. Everything is ad hoc. In the institutional arbitration, we don't find such difficulties, because if the arbitrator doesn't act, immediately the institution steps in, take the role of the court, and see that things are corrected. Here it doesn't work like that. Then we have section 27, assistance, court assistance to take evidence. You may be thinking as to how evidence can be recorded by the arbitrator. If suppose the arbitrator issues a summons, I don't think any witness will come. But if you want to issue a summons to a person for appearing as a witness, you have to file an application before the court. And the court will issue a summons to that witness saying that you are required to appear before the arbitrator on such and such a day. So that is the assistance that comes from the court. You can also take assistance from the court in several other matters similar to this. Then you have 34. We were talking about section 27. This is a provision which where the courts will step in for the purpose of assisting the arbitral tribunal in summoning witnesses and summoning documents. What needs to be done is that an application should be filed under section 27 for such assistance as per the orders of the tribunal by the person who requires such assistance from the court. Then we have section 34, the most controversial section in the Arbitration Conciliation Act. I think that we had a lot of controversies over this provision for the reason that actually we were copying the ancillary model law. The model law said that it should be, the award should not be against the public policy of the country. We have copied it. And thereafter, we started analyzing what is the public policy of India. Public policy of India is not defined in Arbitration Conciliation Act. It is not defined anywhere in any other statutes. And each court found its own definition for the term public policy of India. So the Law Commission of India had to make a Law Commission report just to define the public policy of India. What is public policy of India? Now the public policy has been streamlined. We will find something else interesting in the English Arbitration Act. They say that serious irregularity. The following things are serious irregularities. If any of the serious irregularities are found, the arbitration award can be set aside. The basic understanding in these two laws is one thing, that is, like in the case of writ jurisdiction, when we file a certiorari writ, we will not go into the merits of the case. We will only look at the procedure. Here also, under 34, we have a set of circumstances provided. I'm not attempting to read those provisions because I know that most of you will be aware, or otherwise you will be checking the provisions. There is a list of circumstances which is provided, which would go to the root of the arbitration process. And if the arbitration process is bad, there will be interference. It is not an interference on merits. In both the cases, in England as well as in India, across the globe, the arbitration awards cannot be challenged in appeal, and all what is done is it can be set aside in certain circumstances which is provided. And one of the circumstances was, unfortunately, this public policy, and which is not defined anywhere. So each and every arbitration awards were being challenged until 2015. 2015, we have brought in some small changes. Anyhow, the most important thing that I want to point out is that by the time we realize the importance of an independent arbitration act, the train has already left the station. And countries where, like UK, where they had their own independent arbitration act, and they were inviting people to arbitrate in England and Wales. They just want every other contract to be written that the seat of arbitration is England and Wales. So English Arbitration Act would automatically apply. And therefore, they had a very easy to go arbitration law, while we found ourselves struggling with whether the appointment of an arbitrator by the court is a judicial order or it is an administrative order. Our full bench will consider, then 7 bench will consider, and so on and so on and so on. If you want to read the history, it's a very good reading material. 246 Law Commission report is a good reading material. We will find how the Supreme Court was struggling with this photocopy of the UNCITRAL model law to interpret each and other provisions. They were finding it extremely difficult because it was written by somebody sitting in Europe or America for their purpose, and you are trying to interpret that law. That is your problem. So there is another provision where the courts can interfere, that is under 37. It is under section 8, 9 and 34. 8 is a reference. If you file a suit where there is an arbitration agreement, when the first statement is filed in the court by the defendant, he can say that there is an arbitration agreement. So please refer this matter to the for arbitration. That is under section 8. If such an order is passed by the court, you can file an appeal under section 37. Section 9, I have already mentioned the interim measures. Section 34, you know, the challenge against the arbitration award and appeal from the tribunal directly to the court. That is under section 16. The arbitral tribunal will decide upon its own jurisdiction.